There was a key card in a clear evidence bag, blue stripe, company logo worn almost white. The hole at the top had stretched from years on a lanyard. It stopped working at 4:12 p.m. on Friday, September 29, 2023. Samuel Holloway's shift ended at 5, and that little piece of plastic is why I am talking to you now. Before I go further, I need you to subscribe, not as a formality, because there is one piece of evidence in this case, something small, something easy to overlook, that changed the entire direction of my ruling. I want to make sure you are here when I get to it. Subscribe now. The file reached me in June of 2024. I remember the morning because it was ordinary. I was standing at my kitchen sink, rinsing out a coffee mug with a chipped rim, when my clerk texted to say a late evidentiary packet had come in. By noon, I was reading pension summaries, payroll adjustments, badge logs, and a retirement approval letter dated 6 weeks before the firing. By 3 that afternoon, I understood that this was not only about a man losing a job. It was about whether someone with authority could reach into the last hour of another person's working life and cut it away on purpose. When Samuel Holloway walked into my courtroom, I noticed how carefully he moved, not weak, careful. He wore a dark suit that had been pressed at home, and one sleeve sat a little short at the wrist. He carried a brown folder, but he did not open it for the first 2 hours. He sat down, straightened a pen beside a notepad, and folded his hands as if he had spent a life around machinery and knew where not to place them. The first thing he said that stayed with me was quiet. He said, "I did not ask them to celebrate me. I asked them not to erase me." There was something else about him that mattered to me. He was not defined by the harm done to him. I could see that even before the evidence began. When one of the lawyers stumbled over the date of a shipping report, Samuel corrected it under his breath, not to help himself, but because he still cared about getting the details right. Later, I learned he coached youth baseball on Saturdays for 11 years. That fit what I had already seen. He was a man who had lived a full life outside the injury that brought him to court. Martin Kessler came in differently. He was the owner and president of Kessler Industrial Supply on West Mount Street in Columbus. I watched him before he knew I was watching. He did not look toward Samuel. He looked at the room itself, almost as if taking inventory. He set his phone down face up. He adjusted his cuff twice. He leaned toward his lawyer while the clerk was still arranging exhibits. When the bailiff told everyone to rise, he stood fast, but not fully still. One finger kept tapping the edge of counsel table. Men tell on themselves in small motions long before they speak. The incident itself took place on Friday, September 29, 2023 at Kessler Industrial Supply, 2149 West Mount Street, Columbus, Ohio. Samuel Holloway was 64 years old. He had worked there 39 years and 9 months. His retirement had already been approved. His final shift was set to end at 5:02 p.m. At 4:12 p.m., his badge stopped working. At 4:14 p.m., he was told to come to Martin Kessler's office. At 4:19 p.m., security escorted him out through the employee side gate. I was not in that office, but by the end of trial, I knew it well enough to picture it whenever I closed the file. The desk faced a glass wall that looked out over the floor. The blinds were half open. One witness said she could see Samuel's hands resting on his knees while Martin spoke. According to the testimony, Martin said, "You are being terminated for insubordination effective immediately." Samuel said, "For what?" Martin said, "You know exactly what this is." Samuel said he did not. Martin said, "Then that is part of the problem." That was how it happened on paper. The human part was shorter than it should have been. What brought the matter into my courtroom was not only the firing. If this had been nothing more than a disputed employment decision, it would have stayed elsewhere. But the file contained altered records, false discipline, deleted messages, and benefit calculations that vanished and then came back through forensic recovery. It became a criminal case because the state alleged that Martin Kessler did not simply fire a man. It alleged he created false cause after the fact to block benefits already within reach. There is a detail many people do not know about cases like this. When a company controls the badge system, the payroll software, the HR file, the discipline forms, and the pension records, it also controls the story at first. That is why courts pay such close attention when those records start changing after a decision has already been carried out. If one side holds the whole paper trail, that side does not get much grace when the trail suddenly bends in its own favor. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. Each morning of trial, I watch both men enter from the bench. Samuel always came in through the left door with his lawyer, one hand on the strap of that brown folder. He did not scan the gallery to see who had come for him. He sat down, took out his reading glasses, and lined them up beside his pen. On the second morning, before anyone spoke, he turned his wedding band once around his finger and then put both hands flat on the table. It lasted less than a second. I still remember it. Martin came in with the restless pace of a man who believed he should already be somewhere else. His lawyer usually spoke first, sometimes before they even reached the table. He carried no papers. On the first day, he looked at me once while walking in, and it was not a look of fear, it was a look of calculation. On the third day, after a long session the day before, he came in with no coffee and no phone in hand. That was the first sign I saw that the case had finally entered him. The first wave of evidence established the baseline facts. Samuel's personnel file showed steady evaluations, no major discipline for over a decade, and a retirement packet approved on August 17, 2023. There was an email from HR on September 21st about a retirement cake set for 3 p.m. on his final day. There was a card passed around the warehouse. There were texts between Samuel and his wife, Diane, about whether she should bring a camera for the little gathering. None of that proved a crime by itself, but it showed the company had been treating his departure as retirement, not termination, until the final hour. Then came the badge report. Employee badge 44718, active at 4:11 p.m., inactive at 4:12. Scheduled shift end 5 p.m. The defense tried to treat that as routine once a termination decision had been made, but that was exactly the issue. When was that decision really made and why? I watched Samuel when the badge record went up on the screen. He did not look at it. He looked down at the tabletop as if he already knew those numbers better than he wanted to. The second wave of evidence made the case less simple, which is how real cases tend to go. Martin's side said Samuel had become difficult in recent months. They said there had been a forklift safety issue on September 27th. They said he refused a direction from a supervisor on September 29th. They said the firing had nothing to do with pension timing and everything to do with conduct. Those arguments had to be taken seriously. Employers are allowed to fire for cause. Courts are not there to second-guess every hard decision made at work. But the documents did not behave the way truthful documents usually do. The forklift report listed Samuel as the operator, yet the shift roster showed he had been training a new hire in receiving during that same hour. The written warning dated September 28th carried the same printer code as the termination memo dated September 29th. Samuel's signature line was blank. When Paula Reed from HR was asked why, she said, "He never saw that form." She said it softly. In the gallery, Samuel's daughter Lena pressed her fingers against her forehead and stayed that way for several seconds. One witness from that second wave has stayed with me. His name was Ernesto Vega, a dock lead who had worked under Samuel for 11 years. He did not come in trying to save anyone. He answered like a careful man who had learned to keep his words trimmed at work. He said Samuel had trained half the floor. He said the retirement card had already been signed by most of the department. Then he said one sentence I have never forgotten. He said, "At 3:40, Mr. Kessler told us not to set the cake out yet. It did not sound large, but it meant Martin already knew he was about to stop that retirement before the claimed insubordination had even occurred. I have told this story before, to colleagues, to my family once, and every time I get to this part I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it." The third wave of evidence changed the case. It came through Noel Benton, the company's IT manager, and a forensic accountant brought by the state. Noel Benton was careful and plain. He did not give speeches. He brought server logs, creation stamps, and export records. He showed that the termination memo placed in Samuel's file had not existed at the time Samuel was walked out. It was created at 4:37 p.m., modified at 5:06 p.m., and printed at 5:11 p.m. By then, Samuel had already been out of the building for nearly an hour. The stated reason for firing had been written after the firing. Then the forensic accountant brought in a recovered spreadsheet from an archived folder called Q4 Exposure. Line 18 read, S. Holloway, Vest 92923, Company Exposure $187,306.14 Pension, $22,480 Bridge Health. Next to that entry was a note that said, Avoid if separated before completion of shift. The defense objected. I overruled it. It came in. Martin did not look at the screen. He looked at the wood trim beneath the witness box and held his jaw so tight I could see the muscle move. Then came the moment I asked to have repeated. Paula Reed returned to the stand on recall after limited immunity was arranged. She had decided, finally, to stop protecting what had been drafted for her. Her hands shook once and then went still. She said Martin had called her into his office at about 3:55 p.m. that Friday and asked her a question. I told her to repeat it for the record. She said, He asked me what time 5 o'clock becomes earned. The room did not move when she said it. I have sat in many quiet courtrooms. This was a different kind of quiet. Paula then said Martin told her, He does not get to cross the finish line on my payroll. A voicemail played after that. His voice was calm. That mattered. He said, If Sam walks out retired, we own that package. End it today. I do not need raised voices to understand intent. Sometimes calm tells me more. The defense still had every right to answer, and I let them answer fully. They said the spreadsheet was a planning document, not a scheme. They said businesses talk in numbers because they have to. They said Paula Reed was saving herself. They said the timing looked bad, but bad timing is not the same as a crime. They argued that Samuel had become resistant to management, and Martin made a hard decision late in a difficult quarter. I considered all of that. Fairness does not count unless it is given when the answer seems obvious. Then Martin Kessler testified. Some defendants gain ground on the stand, some lose it without meaning to. He began in control. He said he respected Samuel's years. He said a business is not a charity. He said it quietly. I wrote it down. Later, when his lawyer asked why he acted on that Friday, he said, I had 214 families depending on me, and I could not let one retirement package put all of them at risk. He meant it as justification. What I heard was a man describing another human being as a cost figure with a face attached. There was one sentence that told me even more. During cross-examination, the prosecutor asked whether Samuel had earned a clean exit after nearly 4 decades. Martin looked tired then, not ashamed, just tired. He said, he should have been grateful he made it that far. I wrote that down too. Subscribe if this is the kind of story you want more of. That is the whole pitch, no speech. Just subscribe if it is for you. While I listened to that testimony, a memory from my own life kept returning. I was 13 years old at my mother's kitchen table outside Newark. My father stood by the back door in his work shirt, blue with his name stitched over the pocket. He had one boot on and one boot off. His lunch pail sat on the floor. My mother was reading a letter twice because she thought the words might change if she read them slowly enough. The plant had cut his department 3 weeks before his pension date. I remember the sound of the refrigerator motor turning on. I remember that nobody cried. Then I remember my father putting on the second boot. By the end of closing arguments, I had made my decision. If I am honest, I had made it before that, but a ruling still lands with its own weight once spoken. On June 14, 2024, the courtroom was plain and still. The court reporter had both hands ready. Samuel sat with his hands flat on the table. Martin had one arm across his chest and the other hand tucked under it. He was looking at the wall clock, not at me. I waited for the room to settle all the way down. I found Martin Kessler guilty of theft by deception, guilty of tampering with business records, and guilty of retaliatory deprivation of earned benefits under Ohio law. I said the state had proved that Samuel Holloway's firing was not a real-time response to misconduct. It was a planned act carried out before the completion of a final shift for the purpose of blocking pension vesting and health coverage. I said the records created afterward were false supports built to hold up a decision that had already been made for a different reason. The first reaction I noticed was not Martin's. It was Lena Holloway's. She had sat through every day with her shoulders high and stiff. When I finished the word guilty, those shoulders dropped, not all at once, just enough to show how much she had been carrying. Samuel lowered his head once, then looked straight ahead. Martin turned toward his lawyer and said something I could not hear. She did not answer him right away. I am telling you this story because I believe it needs to be told. Subscribe if you believe the same thing. That is all I'm going to say about it. Sentencing was harder than the verdict. The verdict told me what happened under the law. Sentencing asked what answer the law should give back. We held it on July 19, 2024. I had read the victim impact statements. I had read letters from Martin's family and from business groups asking for mercy because he had created jobs. I considered all of it. Then I spoke. I said, I am ordering you to serve 5 years of supervised probation, with 12 months in the county work release program suspended on the condition that you violate none of the terms I am imposing today. I am doing that because what you did was deliberate, but I still believe punishment must leave room for repair where repair is possible. Then I said, I am ordering you to pay a fine of $250,000 to the Ohio Senior Worker Legal Defense Fund. I am doing that because this offense targeted a worker standing at the edge of retirement, and there are many people in this state who cannot afford to fight once someone above them decides to move the line, I went on. I am also suspending for 5 years your privilege to serve as an officer, payroll signatory, or benefits administrator for any business operating in this state. That means you may own a company. You may not control who gets hired, fired, paid, or vested. You use that authority as a weapon. You do not keep that privilege. Then I said, I am ordering 600 hours of community service with the Franklin County Senior Employment Center and the Legal Aid Wage Clinic. Logged hours, verified hours. I am doing that because you need to spend time with the people who live one management decision away from losing what they spent decades earning. I was still not done. I said, I am ordering a written apology approved by this court to be read by you in the Kessler Industrial Supply break room within 30 days, before any employee who chooses to attend. That statement will also be published in the Columbus Dispatch business notices and posted on the company intranet for 90 days. I am doing that because harm carried out through public authority deserves public acknowledgement. Then I gave the last part. And there is one more thing. I am ordering full restitution to Samuel Holloway in the amount of $187,306.14 for pension loss, $22,480 for lost bridge health coverage and medical costs, and 24 months of comparable supplemental coverage so that Diane Holloway's infusion schedule is not broken again. I am doing that because your decision did not stop at work. It entered a home. After sentence was imposed, I addressed Martin directly. I said, you did not just fire a man, you targeted the last hour of his working life because the numbers looked better to you if he left through the side gate instead of the front. You cost Samuel Holloway pension security, health coverage, and the dignity of finishing where he began. Your family is here today, and I am not speaking against them. They did not make this choice. You did. Privilege in business is not a private reward. It is a trust over other people's rent, medicine, sleep, and old age. My belief is simple. If you use authority to shave away what a worker has already earned, the court must answer clearly. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. When court adjourned, I stayed seated for a moment, as judges often do. From the bench, you see the first truths people show once the formal words are over. Samuel did not look at Martin. He turned to Diane first. She had been in the second row with both hands resting on her purse. He bent slightly, put one hand on the back of her chair, and said, "We can breathe tonight." A bailiff told me those were the first words he heard Samuel say after sentencing. The room did not feel triumphant when people began to leave. It felt released. The appeal was filed on August 16, 2024, and went to the 10th District Court of Appeals of Ohio. The defense challenged the sufficiency of the evidence, the admission of the recovered spreadsheet, and the conditions tied to Martin's business authority. On May 28, 2025, the appellate court affirmed in full. The panel said the record showed a planned effort to prevent vesting through fabricated cause and altered records, and that the sentencing terms were reasonably tied to the offense and public protection. It took a little over 9 months. I was not surprised, but I was relieved. Later, I learned 2 things that stayed with me. On June 18, 2025, Samuel came back to the courthouse for a restitution compliance hearing. He wore a short-sleeved gray shirt and carried no folder. Before leaving, he handed my clerk a photograph for the file. In it, he and Diane were standing beside a sheet cake at the Union Hall on Parsons Avenue. The cake said, "Retired for real." On the back, Samuel had written, "We did the party a little late." That was his after-the-fact line. That was his way. I also received a compliance update from the Franklin County Senior Employment Center dated September 4, 2025. It said Martin Kessler had completed more hours than required for that quarter and had begun staying after his assigned shift on Thursdays to help older job seekers set up email accounts and upload resumes to hiring portals. The report did not ask me to soften anything. It did not call him changed. It simply stated what happened. I read it twice and filed it. The question this case left me with is not whether Martin Kessler broke the law. I answered that. The question is this: at what point does looking at people as cost become so common that the person doing it no longer hears the cruelty in their own words? I still do not know. I only know what I heard in my courtroom. I heard one man ask what time 5 o'clock becomes earned. I heard another man explain that he had in fact shown up for his own life. If you know the feeling Samuel carried into that courtroom, then you know it is not only fear, it is the strange shame of having to prove that what was done to you was real and that you did not somehow deserve it because someone with a title said you did. I recognized that look in his face the first day. If that look is familiar to you, then hear me clearly. Paper can record harm. It does not get to define your worth. And if you sit in Martin Kessler's chair in your own life, if you approve payroll, sign terminations, cut benefits, move people around on spreadsheets, then here is the question I wanted to ask him and could not ask from the bench. When did you begin speaking about another person's earned day as if it belonged to you? Ask yourself that before the next hard call. Then do one plain thing. Put the full record in front of you and read it all before you act. If you would be ashamed to explain the decision in front of the worker's family, your HR staff, and a court reporter, stop. I come back to that key card, blue stripe, white logo almost worn away, inactive at 4:12 p.m., shift end at 5, small enough to overlook, large enough to hold the whole act inside it. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments are where people who care about the same things find each other.